We are here in the matter of Sharrabark Estates Condominium Association versus Lottie Birkenpass.
And this matter comes before the court today on the Plaintiff Sharrabark Estates Condominium Association motion for entry of default judgment and a permanent injunction against the defendant, prohibiting her from essentially violating the condominium association rules regarding the amount of animals within the condominium. So, counsel, will you place your appearance on the record?
Yes, Your Honor. Livia Comoro, P85454, appearing on behalf of Plaintiff Sharrabark Estates Condominium Association.
Very good. And Ms. Camaro, have you heard at all from the defendant in terms of any response to this motion? I note that she's not present for the hearing. Of course, I assume she was provided with notice. In fact, I believe I saw in there a notice of hearing indicating this would be conducted by Zoom today. Any knowledge as to what her status is at this time?
No, Your Honor. Since the inception of the litigation, I have not heard from the defendant at all.
Okay, so this is a radio silence type of case where we're just simply not getting anything at all from the defendant in the matter. Well, your brief was very well written. I thought. Anything to add to it at this time?
Nothing in addition to the brief, Your Honor.
Okay. Well, in that case, I will grant the standard for default judgment is well established in there regarding the condominium association's claim, and they have established their entitlement to default judgment, and that's at least partly based first on the validity of the claims asserted by the condominium association, and secondarily by the total failure of the defendant, Ms. Birkenpass, to plead or otherwise appear in this case to contest the position of the condominium association. With regard to the permanent injunction, I do find that the condominium association has established the requisites for a permanent injunction in this matter, in that the nature of the interest to be protected is, of course, the very, core of condominium associations' existence is the agreements that they reach and are signed by condo owners. Within that, agreeing to comply by certain rules and regulations. That makes the whole condominium method of ownership acceptable to multiple people, not just to any one individual, but also to individuals who agree to abide by certain rules so that they can coexist. And thus, as stated by the plaintiff in this case, these agreements are valuable property rights. That's Village of Hickory Point Homeowners Association versus SMIC. 262 Mishap 52, 2004 decision of our Court of Appeals. The second prong to be analysis by the court is the adequacy of the injunction or other remedies. That is, could I impose a different remedy here, primarily probably a financial remedy that would put the condo association in the same status. And in this particular case, the answer is no, because even if I find or allowed, some sort of financial remedy, it still wouldn't completely offset the ongoing harm caused by Ms. Birkenpass apparently assisting on exceeding the number of animals. And I will note here, I'm not making any statements about, Ms. Birkenpass may have, the welfare of these animals at heart and be a very compassionate and animal loving person. And all of those things are very good attributes, but not all of them are necessarily things that you can put into practical effect when you're living in a condominium association like this. So I just simply don't think that a financial, or another lesser remedy than the permanent injunction would create a situation that would be acceptable to all the other owners here, given that it's not only there are too many animals in this unit, but that they're creating waste, and of course the smells and potential property impacts that we all know can happen when you have a large amount of animals in too small a space. It would, be roughly the equivalent of an apartment owner saying, I want to keep a goat or a dairy cow on my premises because it's benefit to me. Well, of course you can't do that. There are restrictions on that, and they're for good reason, and the benefit of everyone living in those circumstances. Part C is the association did not delay in filing the litigation, and we'll note that that has not been the case here. This has been known to defendant for well over a year at this point, having been sent a violation letter on November 6, 2025, and having well over a year and a half at this point to fix the problem, and just simply has failed to comply, and thus resulting in the filing of the lawsuit in February 2026. So there was no delay in filing it. And the association, Part D, did not engage in any misconduct. Again, not a case here where, they sent in thugs to throw these cats out on the street or whatever. Rather, they've gone about this exactly the right way, and the painful and expensive way of litigating it. However, it's exactly the way that the civil law is intended to operate in the U.S. They've acted, within the boundaries of the law, and as I said, their complaint appears to be totally well-founded to the court at this time. Part E is the balance of the hardship to defendant. If the injunction's granted, and the association will suffer if it's denied. Well, defendant's harm here, even in the absence of any pleading, is presumably her, conscientious desire to care for wayward animals. Again, a commendable thing. However, she can do that by volunteering at the Humane Society. She can do that by establishing a shelter for animals herself in a location where such a shelter would be within the permitted use. For that matter, she could sell her condo and purchase a piece of property appropriately zoned and do that. And of course, aware of various properties that do that within the bounds of the law in the community. So, she does have other ways that she can pursue her heart's desire. The not true necessarily of the association or the other owners. They're there. They want to live by the rules, and they simply can't do it if she continues to operate, what is a de facto animal shelter in her condo. And that same reason, Part F of this says the interests of third person and the public support the issuance of a permanent injunction. Well, again, as I've said already, the third persons here, of course, are these condo owners. They're not necessarily parties, but they're represented by the association. And no doubt they want and they're not only enforcing the animal rules here, they undoubtedly want all other owners to comply with all other association rules, including the payment of assessments and obeying, limitations on what can be placed outside the condo. For example, I know many do have limitations on flags and banners and things of that nature. And it's for everyone's good in the association that people agree to abide by those rules. And by doing that, by signing that agreement, they create what we refer to as a private law. It's a law that binds the people in there, just the same as it would be if it was passed by the county commission or the state legislature. Finally, G, the seventh factor here is that the permanent injunction is framed and scoped in such a manner that there are no issues. Well, there are issues. There are always issues with enforcement. However, let's cross that bridge when we come to it. One certain way of enforcing it is by, a financial type of penalty. As I stated before, I'm not certain that would do a whole lot of good, though it might convince the defendant in this point to change her ways. Some other ways certainly that appear to the court are enforcement, though I certainly don't want to go there if not necessary, would be through contempt of court or, additional, actions that might be filed by the condominium association. So, thus, I will find that a permanent injunction is warranted in this matter. The final issue is the association's entitlement to attorney fees. And the association claims that it is entitled to attorney fees by contractual provisions in the bylaws. And those, as I said before, do create this sort of private law. So even though in a case like this, the Michigan court rules don't necessarily provide for attorney fees, the parties can agree to do it. And here, the bylaws very clearly state that the failure of a co-owner, non-co-owner, occupant, or guest to comply with the documents will entitle the association to recover any reasonable pre-litigation attorney fees and costs, as well as the costs, attorney fees, reasonable attorney fees, statutory fees that are incurred pre-litigation, incidental bankruptcy, and finally, incidental to court action or proceeding, which is exactly what's occurring here. So there is an entitlement to attorney fees in the contractual document, the sections that I just cited, and therefore the association is entitled to its attorney fees. I believe that, did you submit a amount for attorney's fees, or are you going to, I see down here you want the to me to be determined at a later date, so you'll make those submissions post granting of the judgment in this matter. Is that all accurate for your purposes, Ms. Kamara?
Yes, Your Honor, I intend on filing a motion for attorney's fees and costs and going through the purview factors in that motion.
Okay, very good. That's exactly how I believe it probably should be done to make the record as clear as possible. And you'll send me, I don't think did I have a proposed order?
No, Your Honor, I can submit that after.
Yes, if you would do so, under the 7-day rule to give the defendant, the proverbial final bite at the apple here and notice of what's going on, that would be great. And then I'll sign it in due course. And like I say, you did an excellent job briefing the matter. Thank you.
Thank you so much, Your Honor. I can log off now, right?
Yep, I think we're all set. Thank you.
Okay, thank you, Your Honor.